You had to indicate that people who are non-U.S. citizens who are accused of a crime could now be detained until trial, presumably, on the crime.
That's right.
The statutory laws that authorize ICE to deport, to remove someone, they're still in full force and effect. The executive order doesn't change that.
Correct.
So it's going to be a crime of moral turpitude, crime of violence, aggravated felony, et cetera, domestic.
So the issue that the executive order, I think, brings into play is this issue of detention, right? Where now, whereas before, so under the immigration statute, certain criminals must be detained, right?
Mm-hmm.
And so aggravated felons, drug-related crimes where there's been a conviction, crimes involving moral turpitude where there's been a conviction, must be detained, right? Or in some instances, under crimes of moral turpitude, you may not need that, but the burden of proof would be on the government to prove that, right? That there was in fact a crime that was committed. But as it relates to detention of foreign nationals, ICE really has, blank authority to detain as they see fit. In fact, even if bond is issued, so let's assume somebody comes to the United States, bond is issued, they pay, let's say it's $5,000 in bond, and now this person has had an arrest where the criminal charge is pending but no conviction under this executive order, and truthfully under the statute, right? So the statute always allowed this, but I think the executive order now enhances it even more to remind ICE officers, you have authority to do this, by the way, right? This is the executive order. That says now that even if the person hasn't been charged, that ICE could come and now detain these people until the criminal case is resolved, right? But the problem is if somebody's detained by ICE, ICE doesn't comply to state orders. So if you have a client who's being charged with possession of drugs, say, whatever, right? Let's say it's that. And now ICE decides, well, we're going to revoke your bond because that truthfully would be a violation of the bond. But we'll put that aside for a minute because generally they wouldn't do that under the prior administration, even though statutorily they had authority to do that. But they wouldn't do it because it behooved them for them to wait for the conviction, because now they can really deport the person on the basis of the conviction, right? And maybe the person wouldn't be entitled to certain forms of relief that they would otherwise be if there was no conviction. But now ICE, this order enhances that in as much as it now reminds ICE, hey, listen, you have authority to do this, and you can pick them up and hold them.
And how does ICE interact with the state court so that the defendant gets to the state court to get his trial?
ICE, is my experience, has also been, I have a couple of colleagues out here that do immigration law, they don't care. They're not going to bring your client back to state court to fight that. So, hopefully you'll get a dismissal.